In a landmark ruling, the United States Fourth Circuit Court of Appeals rules gender identity is a protected characteristic, and that state coverage bans in trans care are unconstitutional. This will have far-reaching impacts. Wait, that is huge. Wait, hello? And Medicaid bans on treatments for gender dysphoria are unconstitutional. Already subscribed. Fourth Circuit Court of Appeals. Well, glad the Fourth Circuit got it, not the Fifth Circuit. A state or the Supreme Court. The Fourth U.S. Circuit Court of Appeals. I bet this is going up to the Supreme Court. In issuing the final ruling, the Fourth Circuit Court of Appeals declared that transgender exclusions were, quote, obviously discriminatory and were in violation of the Equal Protection Clause of the U.S. Constitution, upholding lower court rulings that barred the discriminatory exclusions. Nice. So they appealed to it, and they upheld this claim rather than challenging the previously held one. The high priests can still undo this, sadly. Yeah. I mean, they could not take it. It would be possible for them to not take it, you know? Maybe. The ruling focused on two cases in states within its jurisdiction, North Carolina and West Virginia. In North Carolina, trans state employees who were on state health plan were unable to use it to obtain gender-affirming care for gender dysphoria diagnoses. In West Virginia, a similar exclusion applied to those in the state's Medicaid plan for surgeries related to a diagnosis of gender dysphoria. Huh. Attorneys for the states had argued the policies were not discriminatory because the exclusions for gender-affirming care apply to everyone, not just trans people. They do this every time, man. It's the same with the homelessness thing. We're not discriminating against homeless people. Rich people also won't be allowed to sleep on the street. Literally, it's not discriminatory to bar things that are for a specific group of people, because everyone's barred from them too, even the people who will never need them. The majority of the court, however, struck down the claim, pointing to several other cases where such arguments break down. Yeah, they keep doing that. They're like, banning same-sex marriage isn't discriminatory against gay people because straight people also won't be allowed to do same-sex marriage. Therefore, it's not a discrimination thing. Nobody can do it. That's literally an argument they made. Does that sound too stupid to be real? That is literally the argument they made. That is actually what they said. That's not a joke. Such as same-sex marriage bans, quote, applying to straight, gay, lesbian, and bisexual people equally, even though straight people would be entirely unaffected by such bans. Other cases cited included literacy tests, a tax on wearing kippot for Jewish people, and interracial marriage in Loving v. Virginia. Like, jurisprudence on this dates back well over a century. Of particular note in the majority opinion was a section on Geduldig v. Aiello that seemed laser-targeted towards an eventual Supreme Court decision on discriminatory policy regarding transgender people. The case, a 1974 ruling, determined that pregnancy discrimination is not inherently sex discrimination because it does not classify on sex, but rather on pregnancy status. Using similar arguments, the states claimed that gender-affirming care exclusions did not classify or discriminate based on transgender sex or status, but rather on a diagnosis of gender dysphoria and treatments to alleviate that dysphoria. The majority was unconvinced, ruling gender dysphoria is so intimately related to transgender status as to be virtually indistinguishable from it. Huh? A good rule. Not only a good ruling, but a good bit of jurisprudence. You know, a good like line that'll be referred to in the future. The excluded treatments aim at addressing incongruity between sex assigned at birth, or incongruity, sorry, between sex assigned at birth and gender identity, the very heart of transgender status. In doing so, the majority cited several cases, many from after Geduldig was decided. I do think, though, that this 74 ruling is bullshit. Discrimination on pregnancy is discrimination on sex, right? Like, that is a female sex characteristic, right? Even a trans man could potentially be subject to it. That is obviously a classification of sex, you know? It's like a second order classification. Like, you need to be of the female sex to get pregnant, at least for now, haha. But like the vast majority, like that is, it's a very like overlapped Venn diagram, basically. Notably, Geduldig was cited in both the 6th and the 11th Circuit decisions upholding gender-affirming care bans in a handful of states. Shitty jurisprudence. That needs to be overturned. But if that's going to be overturned, it has to be, like, from the Supreme Court, and that's not going to happen. Not right now. If you could, would you get pregnant? Are you kidding me? Pregnancy is horrifying. Jesus Christ. Nightmare shit. I mean, miracle of life and all that, but good Lord. In me? Nope. Nope and never. Bro, it literally kills people. Yeah, and I don't even bottom. So like I've got a really tight hole. I'd die during the birth, you know? Okay. The court also pointed to the potentially ridiculous conclusions that strict readings of what counts as proxy discrimination, there we go, um, could lead to, such as if legislators attempted to use XX chromosomes and XY chromosomes to get around sex discrimination policies. Especially where government budgets are involved, there will frequently be a, quote, rational basis for discrimination. A law that pays state employees with XX chromosomes 75% of what state employees with XY chromosomes are paid has a rational, non-discriminatory reason. It saves the state a lot of money. But under the principal dissent's framework, not only would that law be facially neutral, it would also be supported by a rational, non-discriminatory reason. So yeah, this was talked about earlier in this article, but to explain, there were in some former Confederate states, there were literacy tests that were employed before you were allowed to vote, right? You needed to prove that you could read and write to a certain degree before your vote would be counted. Now, a lot of folks couldn't read or write back then, you know, like white folk, black folk. More white people could read and write back then than black people because slavery had just ended, you know, but a lot of people couldn't read or write. But the people who wrote these laws didn't want to block white people from voting. So what they did was they implemented the grandfather clause, basically saying, hey, if at X point in time your grandfather would have been eligible to vote at that time, then don't worry about it. You don't need to pass a literacy test. You're fine. No black American's grandfather would have been eligible to vote during the time period listed because they would have been a slave. So the law, the grandfather clause, didn't specifically target or even mention black people. All it did was mention that if your grandfather could vote at a certain time, then you're fine. Yes, that is where grandfathered in comes from. That is where that term comes from, yeah. But it's obviously discrimination against black people, right? This is the so-called discrimination by proxy here, which, what did I press to make that pop up? I don't know how Substack works. I should find out how it works. Once again, by the way, Aaron in the Morning, Aaron Reed, phenomenal blog. If you want to keep up on anything involving trans people, like she knocks that shit out of the park. Really, really, really good. Like really, really good, you know? A comparison for white and black people across the United States in 1870, 80% of black people could not read and 10% of white. See. Yeah, the obvious purpose of this was to prevent black people from voting, but they wanted to do so in a way that didn't technically ban black people from voting. So they engaged in proxy discrimination, which is, again, what the Sixth Circuit Court here is trying to prevent from happening on trans people with regards to healthcare. I wonder if this is going to get picked up by the Supreme Court. The decision will likely have nationwide impacts on court cases in other districts. The case had become a major battleground for trans rights, with dozens of states filing amicus briefs in favor or against the protection of the equal process rights of transgender people. 21 Republican states filed an amicus brief in favor of denying trans people anti-discrimination protections in healthcare, and 17 Democratic states joined an amicus brief in support of the healthcare rights of transgender individuals. Wacky stuff. Both parties the same, etc., etc. Yeah. This is almost definitely going to be picked up by the Supreme Court, because otherwise this is going to be used as jurisprudence in ways that the Republican states wouldn't like. My understanding, please correct me if I'm wrong, the district courts of appeals are only allowed to accept cases on appeal within the states they control, but their rulings can still be used as jurisprudence everywhere. So the fact that the Sixth Court of Appeals can only take appeal cases from a given set of states doesn't change the fact that this ruling will affect the nation. It's a good thing, so the Supreme Court will overturn this decision. Nice. Well, we await that. Wait, did I say Sixth? I think it was Fourth Circuit, not Sixth. Fourth Circuit.